Yeah, so we are back again. Yes, Fatima ji, I welcome you onto the show. Thank you for giving us your time. And Fatima is a well-settled advocate in Mumbai, and she's talking about banking woes and borrowers' grievances today. So I welcome you, Fatima. It's over to you.
Thank you, Minuji. Thank you so much. So today we'll be discussing broadly about bank-related issues, how banks face a lot of difficulty in recovering their dues when borrowers don't pay, and at the same time, what remedies do the borrowers have when it comes to actions taken by the bank for recovery of the loan amount? So first, I would like to give you all a brief background of what acts are involved in this and under what provisions does the bank have the power to initiate action for the purpose of recovery. So earlier, before the year 1993, banks used to file civil suits for the purpose of recovery of their dues. Thereafter, in the year 1993, came an act called the Recovery of Debts Due to Banks and Financial Institutions, wherein the bank was empowered, authorized to file applications before a specially constituted tribunal called the Debt Recovery Tribunal, which had exclusive jurisdiction to only hear cases with respect to bank and borrower related disputes. So usually the process is that the bank files an application called an original application before the debt recovery tribunal. If they see that the borrower is not paying, so of course, first they have to put the borrower to notice. Once the account is classified as NPA, which the full form is non-performing asset, um, after it's been substandard asset for a period of 90 days as per the as per the norms of the bank and the RBI, they have to classify it as an NPA account, and thereafter they can take steps for recovery. So first they have to put notice to the borrower that you're called upon to repay your dues. If they don't repay their dues, the bank is well within their right to file an application before this debt recovery tribunal, which has exclusive jurisdiction to hear cases with respect to bank and borrowers. Simultaneously, they can also take action under an act called the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act, 2002, where under, if there are certain assets which are mortgaged to the bank, or they have a security with respect to the loan facility, they can go and take steps under this to enforce that security. So why this act, you would ask me, when already there is when already we have a recovery of debts due to banks and financial institutions, is because if the loan is secured, the bank can take action under the act which I just mentioned, which is commonly known as the SARFAESI Act in legal terminology. And without least interference of the court. And the same was done for the purpose so that banks don't have to face a lot of delay tactics from the borrower with respect to recovery of their dues. Because usually we know when any case goes to the court, it takes unusually very long sometimes, or rather the opponent always has various adopts various tactics to delay the proceedings. So the whole purpose of this act was to ensure that banks, considering that they are public dues, they don't face a lot of difficulty in recovery. And when they have a secured asset, they can enforce it. Having said that, there are a lot of checks and balances as well when it comes to the SARFAESI proceedings. Why I say that is because the banks have to follow certain rules or certain benchmarks for the purpose of enforcing the security. For instance, when they take any steps under the SARFAESI Act, say for example, X has taken a loan against property, and they have mortgaged against that, of course, a flat at car, So the bank will first have to, under the SARFAESI Act, give a notice under the provisions of Section 13. It's called a demand notice. They have to call the borrower to repay the dues within a period of 60 days. If the borrower doesn't repay within the set period as mentioned, they can go ahead and take symbolic possession of the property. Now, when I say symbolic possession, that means fixing or pasting a notice on the conspicuous part of the said property or the mortgage property, and alerting everyone or the public that this is a property which is mortgaged to the bank and nobody should deal with it, and it's in possession of the bank. Now, once that is done, they have to serve a notice to the borrower stating the same, that we have taken symbolic possession of your property. Once that is done, they can take physical possession, which is under Section 14. Section 14 only kicks in if the borrower doesn't cooperate and give over peaceful possession. So they can take forceful possession by filing, again, an application before the Chief Metropolitan Magistrate and or the District Magistrate, depending on where you're filing it, and take necessary orders from there, necessary police protection, and go ahead and take physical possession of the property. And thereafter, they have to take steps with regards to sale, issuing public notice with regards to sale so that they obtain more or better price or valuation for the property instead of doing a private treaty. And at all these stages, the bank is supposed to intimate the borrower of every step that they are taking. Any violation with regards to the steps taken under the SARFAESI Act can be challenged by the borrower within a period of 45 days. And they have to avail it. So there are various remedies for the borrower when we talk about the SARFAESI Act, because usually banks, they do follow the provisions of the SARFAESI Act, but there are times when there are a lot of breaches in terms they don't make paper publication, they don't appoint a proper valuer to value the property, or the value of the property is X, but they sell it at X minus 1, which is also a glaring breach. And the whole purpose of the act is to maximize the value of the asset. And if they are unable to do that, the borrower can always step in and raise an objection with regards to the fair valuation of the property, and set aside the sale and redeem the property themselves. So these are some rights which I'm talking, of course, about the borrower, which I'll come to in detail once I start discussing the rights of the borrower vis-a-vis rights of the bank. And so this is a broad understanding of how the procedure works under the SARFAESI Act. And the RDDB Act, which is the Recovery of Debts Due to Banks and Financial Institutions, which came in the year 1993, as I mentioned before, is with respect to certain unsecured loan facilities that the bank may have availed. Or let's take, for example, the value of the security which is given to the bank. For example, in the previous example that I just gave, say the loan facility was around 50 CR and the value of the property was only 10 CR. So the bank is very well within their right to file an application under RDDB to recover the balance due, that is 40 CR, if they can't recover the same from the borrower under the SARFAESI Act. Now, besides these two codes, we have the Insolvency and Bankruptcy Act, which came in the year 2016, which was repealed. The Sikh Industry Companies Act, which was formed for the purpose of resolution of companies. So when the companies were declared sick under the Board of Industry of the Financial Reconstruction, it was a specific board that was constituted. What was happening is that that has been repealed, and we have the Insolvency and Bankruptcy Code, which encapsulates the SICA, which has been repealed, and it is a far it has various more provisions compared to the SICA. It discusses about broadly, again, two aspects. One is resolution of the company. So, for example, if we have a company which is not able to repay the banks the loan amount, they can go, the company themselves can go to the NCLT, which is formulated under the Insolvency and Bankruptcy Code, and apply for resolution of the company. Now, when I say resolution, that means to revive the company. So it gives the chance to the company to restructure or revive themselves from the situation they are in. And assuming that doesn't happen, the NCLT will go ahead with liquidating the company. So first preference or the first aim of the legislation when it comes to the IBC code is resolving rather than liquidating, because resolution of the company would rather be very beneficial, even if we take from the point of view of the economy of the country, considering banks are the support or the backbone of the economy. So instead of liquidating it, where the bank would not get much value,
So they give a
the
helping hand.
legislature, sorry?
They can give a helping hand to the company.
Exactly. It's like a helping hand. So I will get into, I'll give you a brief background on how things work under the IBC, but this is the main aim of the code. So if anyone is going for recovery of their dues, that is not allowed under the IBC. Your petition will be rejected then and there, because the first primary objective is to resolve the problem. So there's usually a committee of creditors that's appointed once the petition is admitted in the IBC. So either the financial creditor, that means a bank or financial institution, can go to court, means the NCLT. Second is the borrower himself. And third category is pertaining to operational creditor. So when I say operational creditor, that means those who supply goods and services. They can also go and approach the court and ask them for admission of a petition against X company. Now, once that company is admitted, there's a committee of creditors that is formed who will overlook the entire procedure and ensure that they get maximum value of the asset or the company, and help the company to stand up on its feet. Now, what happens is usually if the company obviously is in a bad shape, that's the reason it's before the IBC, they call for tenders from other companies who are willing to fund the company and revive the company. So it's like a takeover, or like they would rather buy out the company along with its assets and liabilities. And that money would be utilized to pay the banks and financial institutions or any other creditor as well. So again, the IBC is also a time-bound procedure, just as the SARFAESI is. And it is very beneficial from a lot of aspects, but as we know, a lot of undue benefit is also taken by borrowers under the said act. I think we shall discuss that in the next session, Minuji, when it comes to it. As of now, I think I would like to focus on the rights of a borrower. So, what are the rights of a borrower in case the bank takes coercive steps? So, first is the banks cannot, the RBI circular, there are various RBI circulars that are released from time to time. Because of course they see that banks come off too strong on borrowers, and it's almost like they resort to a lot of rowdy behavior as well sometimes, banks, because they feel they have unbridled powers under the act, and they feel they can misuse it. But there are a lot of provisions which even support the borrowers, and the law is always there to support them if they come with clean hands, not if you're just trying to delay or buy time or take unnecessary advantage of the law. So first is the right to privacy of the borrower. Now, what do I mean when I say that? It means that you cannot, the bank or the recovery agent, once the account goes to the recovery department, they cannot call you during odd hours, not before 8 a.m. and not after 7 p.m. There's an RBI circular for this as well. They cannot just come and take you by surprise and stand at the front of your house door or something. You would be communicating to the bank a specific address where you would like them to meet you. They have to come there. And in absence, if you've not communicated the same, they can always come at your residence or workplace during working hours. Second is there are a lot of times that we have noticed, in fact, the courts have also deprecated on the behavior, how banks go ahead and try to resort to means to recover their dues by, sometimes physical and verbal abuse. It can get really violent sometimes. They threaten as well. They harass the borrower a lot. They make anonymous calls and make false and misleading representations on public domain, which can be very defamatory in nature. And all these things are taken care of. So any such complaint you have, you can always report to the police, or you can report also to a particular forum, which I will come to later. Third point or third right that the borrower has is adequate notice. So as I mentioned a while ago, that the bank has to give you sufficient notice at every stage, whatever steps they plan to take, and they can do so after the account has been declared NPA. There are a lot of disputes sometimes in courts pending, even with regards to declaration of NPA, whether it's rightly or wrongly done. A lot of times, sometimes banks, out of personal vengeance or vendetta, also go ahead and declare the account NPA when it's not. So again, you can approach a court for the same. Fourth right is fair valuation of the property. So the main object of whether we take it the SARFAESI Act or we take the Insolvency and Bankruptcy Code, the object is always to maximize the value of the property or the asset rather than sell it in a distressed value. So the lender must notice the borrower, specifying the value of the asset, the reserve price, the date and time of auction. And if the borrower has a better purchaser with respect to the same property, he can always bring to the notice of the bank that I have a better value, who is willing to purchase the property, and the same must be sold to that purchaser. So it's always better to, as I mentioned even before, it's always better to have a public auction done rather than a private treaty, although the Act permits a private treaty with the consent of the bank. But a public auction would attract or bring in more bids, which would only be beneficial for the bank and the borrower. A lot of times, banks undervalue the property. They don't have it valued from time to time, and they sell it at a very distressed value. which is not permissible. They do that so that, for example, if the value of the property is 5 CR or 5 crores, they will sell the property for 2 CR, although they can fetch 4.5 or 5, and they will just get after the back of the borrower for the remaining, balance dues, whatever are remaining to be paid. So they really don't care, because it's quite a cumbersome process. Once the bank takes possession of the asset, it's completely their responsibility to see that they preserve the asset properly, so that it doesn't deteriorate, and which includes a lot of expenses for the bank as well. So they try to dispose it off as soon as possible, but a lot of judgments are there of the court where they have discouraged banks from selling assets below even the ready reckoner rate, or even when the reserve price is fixed, it has to be fixed as per the bank's internal policies and norms. They cannot just completely devalue the property at one go by 20% or 30% just because it's not selling in one particular auction. They have to give it its own time. Fifth right is balance proceeds. So, for example, if they sell the asset at a high price and the bank has recovered all their dues from it, they can, whatever is the balance amount that they have realized out of the sale of the asset, they can give it back to the borrower. And the borrower is very well entitled to the same, to get all the excess amount from the sale proceeds. A right to be heard. I think that's quite an established fact, as we know in our Indian system, that principles of natural justice are held very close to whatever proceedings are initiated in whatever forum. Banks, either side always gets a chance to represent themselves and have themselves duly represented in person or through a legal representative. Now, having said that, there's one exception to this, that when the bank goes for taking physical possession before the CMM or the DM, as per the requirement, they over there, the borrower doesn't get a chance to be represented, and the borrower has to file a certain affidavit disclosing the nature of the asset, the loan amount, and all the required documents that are in their possession. So there are a lot of checks and balances. If a borrower doesn't have a right to be heard, the law ensures that the same is taken care of, and they are well protected. Seventh is that the bank cannot withhold documents of the property once the loan amount has been recovered or realized. So this is very important, because a lot of times banks withhold the original documents of the borrowers. Even after the loan amount has been paid, they don't return it back. So whenever you're giving any property as security, it's obvious that you have to give the original documents to the bank. But banks do not give it back. Say, for example, a bank has lent A 2 loan accounts. He holds 2 loan accounts. One is a working capital, for example, and the other one is a personal loan. Now, say he has given the security with regards to the working capital and none against the personal loan. So if the working capital has been repaid, the bank cannot withhold the title documents just because the personal loan account has not been satisfied or paid, because the security was with respect to the working capital facility, not the personal loan account. The eighth right that the borrower has is that the DRT, which I just mentioned a while ago, cannot restrain any citizen from traveling abroad or cannot impound the passport. So there are a lot of times that, borrowers are not allowed to travel abroad, or they are said they are defaulters and they should be held in India and they cannot go anywhere, or, they're restricting their right to move around. So the courts have held and observed from time to time that you cannot restrict the right of any borrower from doing so. He has a right to move around wherever he likes, and you are well within your right to enforce whatever remedies you have under law. But this is his fundamental right, which cannot be taken away under any circumstances. And what can the banks, what can the borrowers really do? Now, for example, if the account is bad, or they are not able to pay, or they're finding a little difficulty, or business is going down, either they can approach the bank and ask the bank to increase the tenure of the EMIs or the loan period. That's the first option. Second option, they can restructure the loan. Third option, they can assign the debts. So when I say assign, like there are a lot of asset reconstruction companies who can take over or buy the loan account from the bank. And when that is done, the borrower gets usually a longer period to repay the loan amount. The fourth step that the borrower can take is ask for a temporary relief from the bank or a certain moratorium that I cannot pay you the EMIs from this to this period. But that may come with a heavy penalty. So the borrower may take that as an option if it's fitting their scheme of things. The fifth step that the borrower can take is request the bank to renegotiate on the interest rates by converting an unsecured loan to a secured one. And the last option that the borrower can look at is a one-time settlement. But I wouldn't really advise this unless they are in a very do or die situation, because this may affect their credit scores, and it would become a little more challenging for the borrower to avail a loan next time from any bank. Because banks, whenever they are approving any loan documentation, they have a check at your credit history and what your scores are on certain credit information bureaus like CIBIL and alike. Now, if a borrower has any grievance against steps taken by the bank, for example, declaration of the account as NPA, or charging interest or penalty which is not forming a part of the loan agreement, or undervaluation, as I mentioned, they can always approach a forum called Internal Ombudsman. Now this scheme is extended to all scheduled commercial banks other than regional rural banks, which have more than 10 banking outlets in India. The objective of this ombudsman is to ensure that the borrower gets undivided attention for resolution of his grievance, and they get an independent and auto review of their problems so that they are not partially or wholly unaddressed before they approach another forum, which is the banking ombudsman. Now, this banking ombudsman, as some of you may have heard of, is a senior official who's appointed by the Reserve Bank of India to redress customer complaints against deficiencies in certain banking services covered under the grounds of complaint, which is specified in Clause 8 of the Banking Ombudsman Scheme 2006. Now, currently, there are 20 banking ombudsman centers in India. So you have to approach these within 1 year of the action taken by the bank. And if you're not happy with their decision, you have 45 days to approach the appellate authority, which in this case is the RBI Deputy Governor. You can also approach the court. Of course, you're free to do that. Depending on the financial damage that is done to the borrower, you can also approach consumer forums depending on the value of your financial damage. Because you have the district, state, and national, and they have their own specific pecuniary jurisdictions. All scheduled banks, all scheduled commercial banks, regional rural banks, and scheduled primary cooperative banks are covered under the scheme. You can file the complaint before the banking ombudsman if reply is not received from the bank within 30 days, or the bank rejects the complaint. So first, ideally, of course, you must go to the bank and address your grievances. And if they don't, you can go to the internal ombudsman and then the banking ombudsman. Or if the complainant is not satisfied also with any reply which is given by the bank, you can file it online as well. The banking ombudsman does not charge any fee as such, so you can avail these services. Although I would suggest it's not very effective at all times. You have to do a lot of follow-up, and as most of the provisions with respect to taking action under the banking laws is very time bound, I would always advise that you approach a lawyer who practices in these forums and take timely action. Timely action is very necessary. Meenuji?
Yes. Very
Yes.
informative, enlightened I am.
I hope it was not too fast and
No, it was perfect, like very well explained. Also, the one thing I wanted to ask, you said unsecured loan, we can turn it to secured loan. If you could explain those terms or the procedure, whatever it is.
yes, definitely. So when I say secured, unsecured, secured means I'm giving the bank some sort of security. For example, that security can be in any form. It can be a pledge. It can be I'm giving gold as security, or I'm giving a property, or I'm giving, if I'm a company into manufacturing, I can give him stocks of whatever I am manufacturing, So this is secured. When I say unsecured, that means I don't give the bank any security.
Okay.
He's given me a loan and I'm going to repay the loan as per the terms of the loan agreement. The bank does not have any security as such to give them any sort of safety. But usually banks always take security. There are very few times the banks give unsecured loans if your credit score is great.
Okay.
Or if your credit history has been very good, where you paid on time and there's been no default at any point in time, or they see that you're working and you have enough income coming in, it's all taken care of, you have a home which is in your name, you're staying there. So all these aspects, the banks, there's a lot of due diligence that is done from the bank's point of view. Ideally they should do it, but there are times when they don't, as we have seen in the Kochar case as well of the ICICI Bank and stuff like that. A lot of frauds happen. Yeah, I mean, these are little checks and balances that the banks can always ensure in an ideal situation. But as I mentioned, borrowers and banks always sway, from the norms and procedures that are there.
And thank you for that. And you also mentioned that banks can go on to a personal vendetta. Why would they do that? What could be
So
the
I've seen that in my cases, whichever cases I've handled. One of the cases, especially, which we were dealing in the National Company Law Appellate Tribunal. So under the IBC, there are two forums, or rather three. One is the NCLT. One is the NCLAT, which is the appellate authority from the NCLT. And then if you're not happy with the decision of the NCLAT, you go to the Supreme Court. So these are, in terms of hierarchy, these are the three courts that you can approach. So in my case, I was appearing for the borrower, and I enjoy appearing for the borrower a lot because it's always rather very challenging compared to appearing for the banks, although I'm empaneled with a lot of banks as well. But it's always very intriguing appearing for the borrower because there's a lot more you can work around, and it's very challenging. It's very interesting. It really helps me to push myself as well to do the best for my client. So in my case, what had happened is my client was from Nagpur, and he had availed a loan of 80 CR. And I will not be disclosing the name of the banks and stuff for confidentiality purpose. The bank had given him the loan against certain securities, and the client had defaulted. So the bank had taken action under the DRT and the SARFAESI, which was challenged by us from time to time. And we really stalled the process for the bank, and we made it very difficult for them. So it happens sometimes during the time of the court proceedings, or say the management changes, or sometimes, there's a little heated argument between the borrower and the bank, and the borrower wants to do a one-time settlement, but the bank doesn't agree. And all these factors are taken into account. So sometimes it becomes a very ego battle, or it becomes an ego issue between both of them. And more than recovering the amount, which involves public dues, they are interested in just getting after the life of the borrower, just to ensure that the borrower, learns a very bitter lesson and, doesn't do it again. So in my case, they were not willing to settle with my client at all. And through a lot of strategy, because there was a lot of layering in the matter, it was very, very complicated. We had approached the NCLT as the borrower, as I mentioned to you. And
Oh, I think we lost her.